Good evening to our esteemed guest speaker, Professor Ujjwal Kumar Singh, and the faculty members and students of La Politique. Faith is the bird that feels the light when the dawn is still dark. In this spirit, I would like to welcome all to celebrate the 73rd Republic Day of our nation and to reaffirm our faith in the principles of our Constitution, equality, justice, fraternity through a discussion on the theme of democratic paradox, politics and ethics of Indian Constitution. Before we proceed ahead, I would like to request all participants to switch on their cameras and keep themselves on mute until asked to avoid disturbances. Participants can send their questions in the chat box, which will be later taken up. Thank you. I would like to pass on to Gaurav to introduce our respected speaker.
Yeah, sure. Thank you, Ishika, for the opportunity. Although our Professor Singh needs no introduction, it is my prerogative to introduce him to our attendees today. Professor Ujjwal Kumar Singh is a professor in the Department of Political Science at the University of Delhi. He obtained his PhD from the School of Oriental and African Studies, University of London. Professor Singh has an experience of teaching political science for more than 3.5 decades and has been a fellow at the Center for Contemporary Studies, Nehru Memorial Museum and Library, New Delhi, and taught earlier at Hindu College, University of Delhi and Punjab University, Chandigarh. Moreover, Sir has also been the visiting faculty at various institutions of eminence in the country, including Jamia Millia Islamia Delhi, Punjab University and the University of Pune. He has also worked as a visiting professor under the New Passage of India scheme at the University of Würzburg, Germany, and was also the ICCR Rajiv Gandhi Visiting Chair Professor in Contemporary Indian Studies at the University of Technology, Sydney, Australia. Apart from this, Professor Singh has written and published extensively on laws and institutions, electoral governance, and issues concerning human rights and democratic rights. He has authored many research papers and books which have been reviewed by various international prestigious journals. He is the author of books Political Prisoners in India and The State, Democracy and Anti-Terror Laws in India. He has also edited many books like Human Rights and Peace, Ideas, Laws, Institutions and Movements, as well as Towards Legal Literacy and Introduction to Law in India. It is an absolute privilege and honor for La Politique to have a man with such a dynamic profile among us today. So without wasting much time, I would like to invite Professor Singh to elaborate on today's topic of democratic paradox, a discussion on the politics and ethics of the Indian Constitution. Over to you, sir.
Thank you so much, Gaurav, and thank you so much, Ishika and Professor Oberoi. And I believe this is probably first public gathering where I must congratulate Professor Oberoi because she's probably the first one in political science from Kirori Mal College to be a full professor. So many congratulations, Professor Oberoi, and it's always nice to start with a congratulatory note.
Thanks a lot. Thanks a lot.
You're welcome. You're welcome. Now, the way the talk was framed, the title, it was puzzling. Arman messaged me this democratic paradox that I could make sense, but then the second part, discussion of the politics and ethics of the Indian Constitution, that opened up a huge area. I'm going to just, probably some of you have seen this. This is also title of the book, Politics of the Constitution. I'm not sure whether chapters of the book is part of your reading list, but we do take up chapters from this book as a part of reading list in the MA, Master of Arts. But then, if that is so, then one has to keep on thinking, and I had to think a lot. How to frame the whole idea of democratic paradox. So let's start with some of the obvious ones, and probably we won't be able to do justice to any of these, but I'll go back to history and bring something which is familiar to you, and it is there enshrined in the Constitution. And there is a paradox in some of the provisions over there. Let's take up something which is part of our life today, our biometric identification, popularly what we know as Aadhaar. Now, remember, Aadhaar is actually, it engulfs all part of our life. So for everything you need Aadhaar. Legally, that may not be the very valid position, remember. Court has actually restricted to few services, but today anyone feels very happy. They always carry Aadhaar. So even at the airport, if they ask for your identification document, people show Aadhaar. You go to the bank, people show Aadhaar everywhere. So as a general, in general public brings in Aadhaar. Now, I don't know how many of us really understand the seriousness of biometric identification. A part of our identification is mapped out, preserved in a vault box, and it's claimed that's very secure. But Aadhaar underlines each and every economic activity today, social activity, right? I believe when you were going for admissions also, I think if I'm not wrong, you also have to submit an Aadhaar number, right? Even though it's not, I don't know whether it's legally required or not, but that once institute makes this rule, then we have to follow that, and that's what we keep on doing it. So Aadhaar-like phenomena, which has become universal identification phenomena, you won't find its trace anywhere in the Constitution. This does not mean that this is unconstitutional. It's been accepted, passed by Parliament now, and Judiciary, it has gone through judicial test, it's constitutional. But what you'll find is the text of the Constitution, very rich, very nuanced, lengthy also. But then there's a whole technology and technological push. So there's a paradox. What constitutional values are there, constitutional principles are there, and then the technological advancement, which is very rapid. Not only in this field, these are just indicators. So it's a result of technological leap that we have Aadhaar, and now constitutional frameworks, at least the framework, has to actually rethink in a manner where new technological innovations will find a place. At least the values are in harmony with the constitutional values. Then economy. Economy has drastically changed. Since 1950. Level of production, appropriation, distribution, circulation, it's gone, manifold change, right? The Constitution per se did not have a design of development as such. It gave directives to the state that they have to follow.
ये सिगरेट आप खा रहे हैं
Yes, okay, someone has to, Shyam sir has joined. So Shyam sir has muted. Okay, great to see Shyam sir over here. So, so Constitution actually in directive principles gives us an indicator of the purposes the state is supposed to ensure. It's supposed to ensure minimum wages, equal wages to women and men, bar child labor, fine, and the benefit, the resources of this country has to be spent for the people of India. Article 39, 38, 39 onwards, you'll find it this way. But constitution makers could not, and rightly so, could just even imagine kind of volumes, the way it has increased as such. As a result, in domain of politics, there's a constant. So from the planned development model, we completely changed to neoliberal, where we say planning, just give up planning, right? So it seems there will be some tension between constitutional values and aspirations and the development strategies. Now remember, there's no clear-cut answer over here. There will be always contest over here, okay? Because both the neoliberal and the earlier, the socialist planned development, they would all claim that they are following constitutional values, constitutional principles. So there is a contestation, and we live in this world. And as a student of political science, which you are, many of you probably are, these are interesting contestations, and somewhere you have to figure out what would Constitution say. Can it be resolved, or will it remain as a paradox? The third area, which I think is absolutely important, and the area actually in which you live, you dream, you sleep, or you don't sleep. Okay, I don't know whether you actually sleep. Your generation probably never sleeps. It's social media, it's OTT, it's new modes of communication. I think TV is passe. In fact, when I shifted a flat, I've still not put up a TV. I'm one of those who really watches news, but I'm missing news and cricket, of course. But I think for nearly all of you, you don't miss anything. You get everything on your Twitter, or etc., etc. But there's a whole new world out there. Okay, how would Constitution respond to that? There's an act which was passed, Information Technology Act 2000, and then the amendment also took place. There's famous Shah Singhal case where a woman went to the court and said, okay, certain posts which I'm putting in should not jeopardize my life. Court struck down, said, okay, 66 is gone, and things we won't go into detail. But the idea is you have another whole communication world, a revolutionary communication world, which has opened up avenues to freely express and globally express, not just in terms of a Delhi boundary or provincial boundary or state boundary, globally. So how would modern constitutions, and say, for example, Indian Constitution, cope with a new modes of communication which have come up, a new world which has really come up as such? That's something one has to think. Maybe there's a paradox over here, because the free world, quote unquote, has many cases have resulted into a world of abuse, right? Bully case. Actually there's, it's so much of muck around that, you really don't know where the buck stops as such. So who regulates, right? Does Constitution, will it be Government of India? But then our social media platforms are global platforms. How do you cope up? So these are things which I'm not telling you anything new. These things you're very well aware. All I'm bringing before you, constantly as a student of political scientist, you'll have to think of these issues and connect to the constitutional values by which we have to live, right? So that's something which is there. So these are things which I'm not going to pursue. I know you will have a lot of questions, a lot of debate amongst ourselves. But let me take you back to something which is there in the Constitution, even when it was being, framed, accepted, and when we adopted it, even that time there was a major debate. So I was stuck up by this news item, take me as one other person who's trying to learn, okay? And you are younger, you have a sharper mind, you can make more sense. For me, it was difficult to make sense of this news. This is Indian Express, okay? Indian Express. Dated, this would be January 23rd. And there's a news item, Jammu Kashmir booked journalist saying writes negative, educated may get bail. Read 2 pages, and I like Express. What in these 2 pages Indian Express has done? It's just a reporting. It has, given detail of grounds on which journalist was detained. Okay, which says he's very educated, he's articulate, he's got 1,000 followers. I'm sure nearly all of you would have same number of followers, on friend circle. You have this like and dislike, I believe, where there's some people become friends or unfriend. I don't know how you unfriend them. Probably you unfriend them. And in our lifetime, you cannot unfriend. Somebody becomes a friend. Okay. So, but this is interestingly, person was arrested, got a bail from the court of law, which is perfectly, that's the rule of law. You arrest someone, law will take you to the court. Court may decide, okay, this is a valid case for arrest or not. They may give you bail and you may be released. but he was still accused. Trial will go on. But then he was detained, what is known as PSA, Public Safety Act. Now, detention means something very different. And I'm telling you this because there's nothing worse than getting detained. Okay? As a citizen of this country, as a young citizen of this country, you must know this. I'll tell you the challenges and the paradox over here. Okay? By the way, those who have a copy of Constitution, and hope you have a copy of the Constitution. Yes, yeah, that's what I really like. The new generation lectures are like this. You say something, it's already on the chat box, and you have read something, and before I end, there are two questions. They're saying, okay, sir, are you saying correct thing? This is another interpretation. And this is the best part of the nowadays interaction. I really like this. Thank you, Himanshi. Yeah. So Article 22 of the Constitution is worded in this manner. It says protection against arrest and detention in certain cases. Now I like this. Anyone who will read, okay, will say, okay, I'm protected. I'm protected against arrest and detention in certain cases. But what we'll realize over here, it's not about protection, it's actually about arrest and detention. So no person who is arrested shall be detained in custody without being informed. See the language, constitutional language is like, it's a bit twisted, but very interesting, puzzle also. So if I'm arrested, I have to be informed that I've been arrested as soon as may be. But then there's a clause, as soon as may be. Now, what is as soon as may be is left to the discretion of the executive. Okay, that I'll be informed, but as soon as may be, okay, of grounds of such arrest, nor shall he be denied the right to consult and be defended by a legal practitioner of his choice. So if you just read this clause, it means that if you're arrested, you'll be told the grounds of your arrest, fine, and you will not be denied. Now you can actually have a right to consult a legal practitioner, sometimes legal aid, okay? That's what. And legal practitioner of his choice means, if Gaurav is arrested, okay, not Gaurav, you maybe Ujjwal is arrested, then Ujjwal has the right to choose, legal practitioner, a lawyer of his choice. And then second clause is, every person who's arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours. So there's a check that, police can arrest, but within 24 hours, you have to bring before magistrate. So you have executive and you have judiciary. Okay. So if something wrong is being done by executive, judiciary is there to check you, which is a very important part of modern constitutionalism. That is checks and balances, limited government, okay, and nothing should work in an arbitrary manner. This principle ensures that. So if you try to understand modern constitutionalism, it's an important feature. Executive has a power to arrest, but within 24 hours, accused has to be produced before magistrate, and magistrate would decide whether arrest is warranted or not. Okay? And there's a whole detail. However, Article 22, Clause 3 is very important, and that's what I'm referring to. Clause 3 says, nothing in Clause 1 and 2. Clause 1 says, you have protection against arrest and, Clause 2 says, if you are arrested, you'll be produced before magistrate. And Clause 1 also says you have a right to have a, lawyer as such. But Clause 3 says, nothing in Clause 1 and 2 shall apply to any person who for the time is an enemy alien. Now this category you may have never heard because it's been never invoked. There's something called enemy alien, fine? Within the country. Enemy alien won't have any protection, okay? Hypothetically, you have a neighboring country where there's a terrorism and a terrorist sneaks into the country. The person may be actually categorized as enemy alien. That enemy alien won't have a right to lawyer, okay? Interestingly, even Kasab got the right to lawyer. He was not treated as enemy alien. I'm sure, I don't know how old are you people, but Kasab probably you may have heard some figure, some terrorist figure, and who was hanged. B, clause 1 and 2 would not apply to any person who's arrested or detained under any law providing for preventive detention. Now, realize the crux. If you are detained, you do not have a right to lawyer. And by definition, detention is not punishment. It's just preventive. Now there's a whole web of, suppose you do puzzle, you do crosswords, newspaper crosswords, if you do that, what cubic, I think there's some puzzle there which some of you must be doing and enjoying that, shapes and colors which you do that. Suppose you make a puzzle out of this. It will be very interesting puzzle and very difficult to get an answer. That A, detention is not deemed to be punishment. You have just been detained, okay, for preventive measures. B, you're still not convicted. You are not being punished. You are not being punished, and you're not a criminal. Detainee is not a criminal. It's perceived, it may be seen that this person may commit a crime. Hence, prior to that, the person is arrested. So someone who's detained is not put on trial. It's not put on trial. Someone who's arrested is taken to magistrate and put on trial. There's a charge sheet filed and things like this. Seems pretty legalistic and intricate, but it's not so much. It's a part of the life. The thousands incarcerated as part of detention, under detention laws in this country only. More than thousands, okay? And all kind of detention laws which operate in this country. In Kashmir, Public Safety Act is one of those. And likewise in other parts of the country. NSC is another one, National Security Act, since last 40 years, fine? Now you'll be detained 1 year and then 2 years, something like this. But the important point which I wanted to make was that a detainee does not have a right to lawyer. A detainee is not someone who's a criminal. He's not committed a crime. He is preempted. During election, like there'll be elections in 4 states. During election time, many are detained because the executive, perceives some threat from them during election time, then they're detained. It's part of democracy. Strange that on the one hand we have democracy of elections, and on the other hand detention continues in those provinces as such. Now, issue was paradox, right? Constitutional paradox. Now, one thing which has been told, you'll read in different books and things like this, that detention laws are used in nearly all countries, all democracies. But detention provision is not there in the fundamental rights section of any constitution of the world. So we are very proud of Indian constitution, and rightly so, because it's achieved through long struggle. You have rights guaranteed, you have directives given to the state to ensure at least socio-economic justice, okay? And then you have elaborate length of government and special provision for marginal section like scheduled caste, scheduled tribe, OBCs, you have, and which is very important. Having said that, the paradox is one of the most anti-democratic provision is part of fundamental rights section, part 3 of the constitution. It could be anywhere else, but that's interesting why it was put over here. And then I'm bringing you 2 figures which everyone is familiar nowadays, right? And just listen what they have to say. And then we come back to this. Okay, that's one paradox I brought in. I'll bring you another one. Yes, thank you, Abhay. MISA, Maintenance of Internal Security Act. See, this is the loveliest part, So I don't know whether you are enjoying, but I'm enjoying your company. I don't know, you have given me such a short time, and your timing is like exactly like this. 5:10 it starts and 5:50 it ends. Gives me no leeway, But anyway, this will keep us disciplined. So discipline is in the air, during emergency. Remember, I don't think anyone else will remember. But if you read about internal emergency, Vinoba Bhave actually supported emergency by bringing something called Anushasan Parv. सो एक आप डिसिप्लिन कर रहे हो, एक विनोबा भावे ने लाया था, और एक बाकी माहौल भी डिसिप्लिन करने का है. हाँ, तो मैं उस डिसिप्लिन में रह करके बात करता हूँ. आई एम रीडिंग यू, एंड maybe you can guess. This is a speech given in Parliament on 13th February 1951, and which brings paradox of liberty and restrictions on liberty so vividly. And I know some of you smart enough would immediately go check and put on the thing, but I still leave it to you. Guess who's speaking this? Indeed, the Honorable Home Minister himself started his speech. Honorable Home Minister was Sardar Vallabhbhai Patel. Okay, so Sardar Vallabhbhai Patel gave a speech, and in response to that, there's this very well-known member of Parliament is responding. So indeed, the Honorable Home Minister himself started his speech by saying that he moved his motion with a very heavy heart. None likes any provision for detention of citizens without trial, and especially the honorable members of this house, many of whom were themselves subjected during their active political career to detention without trial. And I know many outside, there is a hands up, but just don't put in the chat box, let me complete this chapter, okay? And then I'll come to that. So I know of many outside who also suffered during the old regime in this fashion. In fact, people outside, not those people who want to create mischief, many people outside were supporters of a strong policy to be pursued by government, get bewildered at the fact that the very people who were sufferers in the hand of a regime which resorted to detention without trial, and the very people who oppose such measures ruthlessly and relentlessly should now find it necessary to enact a measure of this description. This is a speech given on 13th February 1951 against the first detention law. It was titled Preventive Detention Act 1950, okay? It was against this act. A member of parliament is giving speech. He says the paradox is those who suffered at the hand of Britishers, those who were detained, I don't need to look at all those pop-up which is coming up. That takes me away. This is very distracting, but very engaging also. Yeah. So first detention law has been brought in. Sardar Patel moved this motion, and he says he is bringing this law with a heavy heart, and he actually says in the parliament that he had sleepless nights before bringing such law. Okay, now the person, and I don't think, is there anything in the chat box? No, I'm very happy. I'm very happy when you don't have answers, because mostly all of you have all the answers. Prakash Gupta, Prakrit Gupta, very good guess. I don't know which study reflect that you are familiar with Constitutional Assembly debate, because Mahmood Taqi would be one of those who would actually raise certain issues. But any other guess? There's no harm in trying. There's no trophy for loser or winner over here. No? I have, remember, documentary proof. So no, this is Preventive Detention, that's the title. And this is none other than Hindu Mahasabha leader. Aarti, it seems you just see. I don't know. See, Aarti, I haven't seen your response. Okay, I was about to give answer, but Aarti is absolutely right. So you absolutely guessed right. This was Shyama Prasad Mukherjee, Hindu Mahasabha leader, but who was member of Nehru's cabinet. Remember, and then it's Shyama Prasad Mukherjee who is questioning this act. I'm bringing this because in times in which we live, when RSS is there, it's a dominant organization, when Hindu Mahasabha members are there, you can retrieve some of the best ideas from any sources. Knowledge is not monopoly of A group, B group, C group, D group. As a student of political science, we would actually appropriate knowledge from any shade, whether it's left, whether it's right, whether it's liberal, whether it's Marxist. And that's why Shyama Prasad Mukherjee's defense of civil liberties and questioning and his critique of detention laws is a very celebrated piece. It's a very important intervention with Shyama Prasad Mukherjee made, fine? And remember, he himself became part of the government. Having said that, he questioned this and is reminding the members of the Congress, including Sardar Patel, that many of you yourself suffered during colonial times. You went to the prison, you were detained without trial, fine? And why are you bringing this thing? So remember the context which was there in 1950s. Context was one where, on the one hand, communists had raised their flag, they rebelled. They actually were fighting war against Indian government, overthrowing Indian government in Telangana. So on the one hand, communists were there, and Ramesh Thapar, a journalist, had brought this magazine, Crossroads, which was banned, but High Court said no, has a right to actually write. On the other hand, Shyama Prasad Mukherjee and others were raising the whole issue of questioning partition, and they said this partition shouldn't stand. This is wrong. Partition of India is wrong. So you have left wing and right wing both questioning the government, and then government says that, well, we have to work. We have to work as per the constitution. So freedoms cannot be unrestricted. Okay. So detention laws were brought in, and also First Amendment was brought in, whereby restrictions were put on right to freedom, Article 19, quote unquote reasonable restrictions were put over there to right. So no, even when the first the Constitution was adopted, and there itself it was amended and certain restrictions were put in. So see, there's a whole thing about public consciousness, what we believe, what Constitution is giving. And many of us believe that Constitution has, and here you have Ikshul Arora again put in exactly all the sources. I don't know how, after every lecture, all my sources are gone because every source is now in public domain. I don't know, we teachers actually start digging something new, and by the time you come with something new, students already have it. So ab bada wo that game about bada mushkil ho raha hai, because you are so learned and you actually many times are a step ahead. Okay, my time is running. I've got, it seems, 15 minutes maximum. I've got 5:35. So let me go back to what I was saying. In terms of when we look at constitutional, kind of democratic paradox, and specifically the paradox in constitutional democracy, it's important to keep in mind that our consciousness, our citizens' consciousness, our public consciousness pulls you towards one end, and on the other hand, when you look at Constitution, then it's a very balanced, it's very even, it follows the golden mean path. So freedoms are there, but there are reasonable restrictions. Okay, that we have to keep in mind. Equality is there. Right to equality before the law, fine, is there. Equality of opportunity is there. But there's a gap in terms of substantive equality, okay? And constant this tension, is played in our real life, okay? Say someone like, Suhas Palsikar would say, that constantly what we get is a weak, strong state in this country. Because you will have constant demands on the state, fine, for redistribution on the one hand, and state is supposed to play by democratic rules, constitutional principles, but on the other hand, in order to many times sustain itself, carrying on its policies, it tends to take undemocratic steps. And it tends to become repressive, in its nature. That will have detention laws and certain other special laws which will be there. One one, just it's not, these are not final words. Remember, on detention, it is a constitutional principle. It's not just a law. Constitutionally, detention is guaranteed. Fine. The safeguards in the constitution. There's a tribunal, but yes, right to lawyer is not there. And I think that's very important that everyone, even detainees, should from the very first they have a right to legal remedy and to right to consult a lawyer as such. I'm going to bring to just one more section, which again is very important. And I hope you don't play with this category in your real life, in your classroom as such, because that's a very serious concept which I'm going to bring before you. This is right against. Incidentally, what was seen as soul of the Constitution? Any idea? Dr. Ambedkar? Soon you will be preparing for civil services. That's something which is very well known. You type and you will immediately get Article 32. I know before Arman was about to say, see, if just Arman you were typing and I was saying, but anyway, yeah, right to constitutional remedies, absolutely. Even right to constitutional remedies won't work when it comes to detention, remember. But over here, Article 22, just one small section which is important. See, this is just to also push you so that you read Constitution. It's an invitation that you read Constitution. Just don't go by commentaries. Reading D.D. Basu won't be enough. Best is to get a copy of the Bare Act. It's very simple. 4 cups of your coffees. It's there, if you're on KM College, visit sometimes. There's a law faculty at the corner. You'll get a discount. Okay. You just see a student. It's easy. It's good to use. And sometimes read, especially sections fundamental right and principles read. They are like, will give you some very, very interesting ideas to think about it. So Article 20 says protection in respect of conviction for offenses. And then third, clause 3 says, no person accused of any offense shall be compelled to be a witness against himself. Basically a guarantee against confession. A simple point. Aarti is picked up by lady police. Remember, that's another thing which is there. Now lady police only can touch you. And she's taken to Thana. Aarti, I am sure you had no experience with what police does because you're still not in JNU. But suppose you went to JNU, maybe you'll have experience because with all demonstrations, there's a good thrashing and there's nothing wrong. Students do it and they do very, they have fought for democracy of this country. So then, suppose someone is picked up, accused of theft. We know police will give you good thrashing, and then you are asked to accept that you have committed this crime. Okay, it's recorded. Courts will not accept it. Courts accept what you say in the court only. That evidence from police is not. But you have a fundamental right that you will not be witness against yourself. Your confession will not be used against you, okay? Except for certain circumstances, which is there. So it's a fundamental right, okay? But then there were laws which were brought in this country, which compromised with this. And courts accepted this. TADA was one law. Remember, you have a crime of terror. It's a serious crime. How to fight, okay? And then you say, well, these laws are not sufficient. Let's change the laws. And laws were brought in. Very serious laws were brought in. Draconian laws were brought in. TADA and POTA were brought in. Why they were draconian? Because one of the principles which was there is that confession of an accused of crime of terror will be used against him or her. Not only in accused and co-accused in TADA, and then in POTA against the accused. Courts accepted, in Kartar Singh judgment, courts accepted the validity of such provision, okay? It took long time it took. It was actually politics in the sense where there was mobilization, forces came up. Interestingly, when TADA was brought in during Congress regime, BJP opposed it. When POTA was brought by NDA, Congress and UP opposed it. So all parties had the goal of actually opposing and supporting, but they brought the same thing. Okay, and finally POTA was abolished, but the provision was there in POTA. And court, I had actually, I don't know, I probably won't have time even. Supreme Court judges themselves very clearly says it is perhaps too late in the day to, this is judgment by two bench judge of the Supreme Court, who's saying that it is perhaps too late in the day to seek reconsideration of the view taken by majority of the judges in Constitution bench. But as we see, Section 32, which is of TADA, a formidable doubt lingers in our minds despite the pronouncements in the Kartar Singh case that pertains to the rational reason behind the drastic provision making the confession to police officer admissible in evidence in trial for POTA offences. So they have serious doubt why it was accepted by the courts, but they say it's too late now, because by the time even POTA had gone away with. Point which I was making is Constitution is absolutely important, but A, we need to read those. B, if in doubt, we need to question also, because many times the party in power, fine, the politics prevails over the values. And here I'm saying constitutional values. So with the goal of fighting terrorism, we passed laws, and even judiciary accepted, gave validity of those laws. Even those per se, any simple reading, a political science student reading would say, how come this is in the law, even though the Constitution says no, fine? So exceptions were being made. Thank God. The best part is confession before the police officers under special anti-terror laws were given up. Unlawful Activities Prevention Act, the anti-terror law which is operating now, does not have this provision. Fine. So we have made a correction. It's not that part of UAPA, but still it is part of many such laws, like Organized Crime Act. Confession is still there. Fine. So there are tensions within, not within the Constitution, sometimes within the Constitution, right? As in case of detention laws, but not in this case when it comes to confession, not in the Constitution, but the Constitution and the laws which were passed. There was a tension between these two. And thank God it was reconciled. So, 46 means 4 minutes, okay? 4 minutes, let's summarize what we're trying to do. What we're saying that our reading, one, we need to read the Constitution carefully, which is a document meant for citizens. It gives us hope, fine, because we have achieved through long struggle and something exercise, the deliberative exercise was very rich, where Nehru, Patel, Prasad, Azad, as Austin would call them, oligarch, fine, really deliberated. Dr. Ambedkar became an architect who on every single article actually gave his wisdom, his valuable words, and which mattered. So Constitution is not surprising that across the world, whether it's USA, whether it's Russia, whether it's India, whether it's other countries, young people have, they have took hold of the Constitution and they are saying that we stand by the Constitution, fine? That's what they're doing, okay? Whether it's anti-CA or others. Having said that, when we carefully read, there may be internal tensions within the Constitution, right? Austin has summed up very well. The Constitution purpose of the Constitution was, and that's what framers thought, was to bring in national revolution, democratic revolution, unity and integrity, and social revolution. A, democratic revolution, which we still carrying on. B, social revolution, task unfinished. C, ensuring unity and integrity. These are paramount goals which Constitution has, the Constitution makers envision. We are towards that path, but there are certain paradoxes, there are certain tensions also, which we need to resolve. And it's not resolved by lawyers and the members of parliament only. It's actually by us citizens, by learning and following constitutional path. I think my time is up, so I'll stop over here. Thank you so much.
Thank you so much, Professor Ujjwal. That was pretty comprehensive and quite insightful. Good evening, everyone. My name is Arman Mathur, and I'm a first-year student. I will be moderating the question and answer session. So if you have any questions, you put them in the chat. I'll be taking them up. But just to sort of set the ball rolling, Professor Ujjwal, I want to take you back in history to what I see as the very fundamental paradox of the Constitution. We go back to the framing of the Constitution, we go back to its promulgation in 1950, and we see a Constitution which is decidedly liberal. It rallies around the individual, it speaks of liberty, equality, and fraternity. But at the same time, the society in which it is being promulgated was by no means as liberal as the Constitution itself. So you had a society plagued by untouchability, by social perversions like gender discrimination, many of which still persist today. So when Dr. B.R. Ambedkar said in the Constituent Assembly that Indian democracy is a top dressing on Indian soil, which is essentially undemocratic, what he was actually doing was acknowledging and accepting that this is a liberal imposition on an illiberal people. So my slightly provocative extension to that as a question to you would be, wouldn't this imposition in itself be a paradox, and wouldn't it in itself be illiberal? Over to you, sir. Sir, you muted. You'll have to unmute yourself.
Yeah, this is thanks for reminding me. Prakrat will take later. It's important. First, what Arman has brought over here. So you invoke Dr. Ambedkar. I don't know whether you invoke Dr. Ambedkar as Ambedkarite in the sense following his values, or you invoke Dr. Ambedkar in a manner of questioning the constitutional framework itself. But both ways we need to engage. Both ways we need to engage. So Dr. Ambedkar, and I'm sure you and I have read the same speech, where he says that we are entering a world of contradiction. Unlike Nehru says twist of destiny, it's world of contradiction. And contradiction lies in the fact that even though we have achieved political democracy, and which was a revolutionary achievement, we don't realize now, but universal adult franchise, every adult have a right to vote, was a revolutionary step at that point of time, especially what happened compared to what happened in the West, where it took centuries to arrive at this position. India, with large number of illiterate people, remember, did not shy away and said, well, illiteracy is not about knowledge. Knowledge comes in many forms. Literacy certainly helps. But then we have political democracy. However, this will not survive unless we transform this political democracy into social democracy. And then what Arman mentions, that are we imposing liberal framework to essentially illiberal society? Now, the second part is absolutely right. Indian society, in different ways, like Dr. Ambedkar said, that villages are den of ignorance. So in that sense, village republic idea was given up, that we need not start from the bottom up, because there is casteism and ignorance at the level of villages. Fine. So we need to bring certain principles like what Constitution did, certain liberal and liberal communitarian values. Now, Dr. Ambedkar was clear that we Indians lack constitutional morality, right? And he was clear that this has to be inculcated among the people of India. So, sounds like someone patronizing here, but no, he clearly acknowledged the inadequacy of Indian society where constitutional morality was lacking, and it had to be inculcated. So, and I would say even that's true for constitutional values. Bulk of the constitutional values which are enshrined in our constitution, liberty, equality, fraternity is certainly lacking. Public conscience is lacking. Solidarity is lacking in many ways. Fine. But these needs to be inculcated, not by the liberal elite as such, but by the churning which took place through democracy. So democracy as it comes to in India, which is a society which is agrarian and many ways feudal and partly capitalist. Remember, in our nationalist movement, there were peasants who fought for Indian independence. Indian independence movement is replete with many peasant movement as such. The tribal movements, and then also you have labor movement and INA rebellion as such, brutally as such. So democracy was not something which only elites fought for, elites bothered. Democracy was something which was the result of Indian peasantry, Indian tribals, and whole range of disenfranchised masses. So these people were well versed in science of democracy. However, in terms of governance structure, there was some gap. So those who in power and those who were elected to govern were expected to both respond to the demand of the masses and also follow the constitutional visions in order to ensure that the uncivil elements of our civil society needs to be tackled. That's why what we got was a strong state with strong power to actually go against the caste system. Remember, the revolutionary principle core of the Indian Constitution is abolition of untouchability. So equality provision, abolition of untouchability, those were all constitutional values which were enshrined. You may say it may be liberal, but maybe more than liberal communitarian in the Indian context, and there was sensitivity towards that. To that extent, I won't say it was imposition. There was a gap. But soon as, Arman, history has shown that we were able to overcome this gap with a combination of a constitutional democracy, constitutional principles, constitutional values, and democratic churning which took place, right? And I'm sure as a political science student, you read right Kothari, you say there's a competitiveness among castes. So the ritual of purity and pollution is giving way to competitiveness among the caste, which is, more secularization principle. But Arman, these are not answers. These are ways of thinking. And thank you for framing this question in this manner. Okay.
Thank you, sir. I think that's very interesting, and we do have a variety of different very interesting questions which have come in. And I think what you've said about the liberal and illiberal thing is very interesting insofar as you're talking about it being more of a liberal overlay, a veneer over society, and the main gist of it being dependent upon churning, the manthan as we call it in Hindi. So Prakrat and Aarti sir have come up with two very similar yet very interesting questions. Prakrat is asking about the paradox of the sedition law being retained despite its colonial legacy even after the British have abolished it, while Aarti is speaking about the fact that we do have a strong federal structure with the same set of rules and laws for each individual, but at the same time we have special provisions with wide discretionary powers given to the central government under the 5th, 6th and 7th schedule. Is this also not a contradiction or paradox within the constitution? So I would like you to answer both of these questions in a combined sort of way, because I feel they're very related insofar as they are speaking about discretionary powers. Over to you, sir.
See, Arman, these are not easy questions, okay? You asked me to combine these whole thesis, okay? But see, they are sedition, of course, that's kind of maybe it's in the air all the time. And whether you people like it or not, your generation is pretty seditious, okay? So let me not say more than that. So some of the youngest, and Devangana, Kalita and others, you keep on hearing names, charged for sedition, going to prisons. And these are all very, very young students, at least I won't say what happened to young people. Thank God we have young people. That's how this country is living by. People used to talk about gentrocracy earlier, but this is the time for more young people. So sedition, it seems, there is a paradox over here, because and I'll tell you something which scholars have worked on. There are books from this. But I remember one of my senior colleagues from Delhi University, Professor S.K. Chaubey, who's got a very important book on constitutional assembly debate, Springboard of a Revolution. He once asked me, and this is month before this debate happened, I think around 25 years back, he said, how can republic and sedition go together? Because republic is about power to the people. It's not just about elected representative, remember. Janapad, Mahajanpad, it's power to the people. When people have power, how can you have sedition as such? Sedition, remember, is and Hindi would be better. It's seen as it's Rajdro. It's projected as Deshdo. It's not Deshdo. It's not against country. It's against, it's challenging the state power. Okay. So how can both go together? Because if people who are there, having said that, debate took place. The statute remained, but in terms of constitutional provision, it's not there. Okay, in constitutional provision is not there. As a statute, part of IPC is still there, and no less than Arman, no less than Prakrat. Thank that I got your pronunciation right, Prakrat. No less than the present Chief Justice of India, who himself questioned that how can this law stand? But again, remember, beyond party lines, all regimes have actually practiced and enforced sedition law, whether it's Congress regime, UPA regime, NDA regime, left regime, as many sedition cases in Kerala, I believe. So they all have actually carried on with this, but there is a gap because, you have a right to express yourself, and there are other elements of criminality. As far as researchers have shown that when such charges go to highest court of the land, they don't sustain, because ultimately your whatever you speak, your speech act, if it results into violence, then it will be seditious as such and things like that. But I won't go into detail of sedition. Someday if you have a whole session on sedition, that will be very, very interesting, worth debating. Then was it Aarti's question about distributing power to central government?
Yes, sir. Yes, she was speaking about.
So we do have a strong federal structure. Now, I see it's not about discretionary powers. It's actually constitutional safeguards under 5th and 6th schedule to certain sections of Indian population who historically have been marginalized. So it is tribals in northeastern states, except for Manipur over there, and central part of India, where there are tribal rich areas. So 5th and 6th schedule would deal with those. In fact, if you read very carefully, those are very interesting part of Indian constitution, because they actually have constitution within constitution. So the governor under tribal advisory councils will have enormous power over there. Sad fact is it's not been really materialized in central part of the country. The 5th schedule part is not operational in that sense, because the whole tension, remember, between mineral rich resources area where the tribals who are inhabitants and the benefit which goes to them and actually does not go to them, and the gap it creates. So how come the richest in terms of resources, the areas and the land and the people, are most backward in terms of economic benefits? So even though central government may and should ensure that a more autonomous decision-making process starts over there through autonomous areas and councils, it has not bore the same fruit as such, because finances are centralized. Fine. So central government actually centralization of finances, which really curtails. So paradox is that constitution actually gives autonomy to different areas to pursue their own development needs, but the funding is like, that the resources go to the center as such. A very limited answer, Aarti, but more to think on those lines. Arman, you're muted.
Yeah. So thank you for that. I think that all really brings us back to that we should read the Constitution very carefully, because it seems to be a very interesting document, and it has so much within that huge corpus that there's a lot to explore. And sir, the next question by Manya is very interesting, especially for you, because I know you've written a very interesting essay in the Economic and Political Weekly back in 2003, where you have explored this concept of what you call a democratic dilemma, right, between the assertion of authority at the expense of citizens' liberty. And you've explored very interestingly this idea of the undemocratic and the extraordinary. So it would be very illuminating if you answer this question in that context. Manya asks, we have had many instances where political incentives have led to the instinct of giving precedence to ends over constitutional means, like the purported justification of the emergency. This leads to the perception of a paradox between the two. Is there indeed one? And if so, can it be overcome? I would add to this the debate over the First Amendment, sir, which you've mentioned in your lecture, where the purported justification of the First Amendment was because Nehru wanted to go forward with the land reform legislations and a variety of different things. And he was basically saying that we've gotten a mandate and we need to fulfill these ends, and therefore we can give precedence to those ends, however democratic, over these constitutional means. So, sir, it will be interesting to see what you have to say on this.
Yes, and I don't know, before I respond, I hope someone actually save this question and please mail me, because see, remember, there are many more questions, and these are not thoughtful questions. These are not. It's not a press conference questions. Where someone asks and put a mic and say, "Give me a bite." These are very serious questions and very important questions which have been raised over here. And I'm scared you people have done some homework, which is uneasy for me. Right. Ends over constitutional means. It seems, either way this justified. Once an executive takes a call, there is always a justification lurking somewhere in some provision, some footnote, and it's justified. But larger thing is, which probably Nehru articulated so well. It wasn't in the word of Nehru, it was word in Upin Bakshi, but that was the meaning one was getting. That constitution becomes just means to achieve certain ends, and certain ends mattered a lot. Those ends mattered a lot. Say, for example, to bring about social revolution. In fact, because such a reflective session which I'm having, such a very, very rich, and knowledgeable question, let me just be a bit reflective over here. So, in terms of political democracy and political realm, there are always ups and downs, the setbacks. Say, for example, contemporary period, many would say it's undeclared emergency. Arvind Naran has a book. And then, as a political scientist, you want to be even, and you question that, no, this is just one viewpoint. After all, even with pandemic, Indian people have survived. They have not become destitute as such. They have got benefits. Aadhaar, with a lot of criticism, actually helps in benefit reaching to most marginal section. Kisans get their due. Old age pension is there. Insurance works. Ayushman Bharat insurance works. So what you'll find is social inclusiveness and social reach has increased, both by the government and otherwise. So this social churning which happened, second democratic upsurge, and then later on, which for many, disprivileged, they will say, I'm not bothered. If I'm getting that little bit of pie in that national thing, I'm happy. Why are you rich people? Why are you educated people very unhappy with us? We are getting our due. So you have one big response over here, that social democracy is prevailing, even though political freedom may be under question different areas. Sometimes there's a critique of Mamata regime in West Bengal, sometimes in other areas as such. So that ups and down goes up. But to actually talk in terms of the fact that ends have a precedence over constitutional means, only in limited way it did have. Say internal emergency, it did. But yes, there are emergency laws which do not come under purview of article emergency provision of the Indian Constitution. So AFSPA is one law, Armed Forces Special Power Act, and you have seen what happened in Nagaland, what is happening in Manipur and Nagaland nowadays. It's happening for many years. It comes up sometimes once, it's a boiling point, then it's it's resolved at that point of time. So in certain areas, it is true that the ends are justified. Say law and order, security, national integrity trumps over freedoms, individual, collective, community freedom as such. Those times it's pretty obvious, and let's accept that those are challenges which Indian democratic state is facing, and how best we can resolve in a democratic manner. That's what we have to think. So we can't close our eyes to spots where there are trouble. We have to acknowledge. Only when you acknowledge the troubles, you'll be able to respond to those. That's something which we have to accept. In that sense, there have been justification of extraordinariness, though not terming them as emergency, right? We do not bring under that framework, so that we keep this veneer of civil administration, even though it's actually army which dominates over there, rules over there. And remember, army is actually there to defend us. So we cannot question the agencies. Agencies are playing very important role. It's about political leadership. So in that sense, remember, constitution, which is a product of politics, will survive and it will grow only with certain kind of politics. You cannot take away politics from that, fine? So we as the individuals, we as a student of political science, we need to have a politics of reconciliation, politics of dialogue, politics of engagement, right? Politics of dialogue as such. That would be resolved to many of the challenges facing this. But Mania's question remains, it is just, I made a starting as such. See, I'm so scared of your discipline nowadays, so Arman would say, okay, your time is up, sir. He'll have very polite words. That's why I want to save this question, so that I have to think more. Yes, Arman, please.
Right. So I think it's very, very interesting to see that a lot of these paradoxes which we are coming across, they do lead back to that fundamental dichotomy which Dr. Ambedkar pointed out in the Constituent Assembly between social and sort of political democracy. And I think that's something which I would like to highlight for the audience, because it's very important to understand how prescient these people were who have framed our constitution. So, sir, actually, I'm so sorry. It's so ironic that I have to say this, but we are actually running out of time. And I only have time for like one more question. So, and all of these are like pretty interesting questions. So I'll just take up the first one, which I can see in front of me. And that is a question by Gaurav Bisaria. He asks that the provision of the 9th schedule was made for laws which aren't under the ambit of judicial review first. Then, after the Keshav Nanda Bharati case, the Supreme Court stated that every law after 1973 would fall under its power for judicial review, with the Supreme Court coming up with the basic structure doctrine. And in several judicial precedents, it has been observed that when it comes to the interpretation of the Constitution, often the judiciary and the parliament are not on the same page. Why is it so, and how can this be changed? I'll add to this, does it need to be changed? And I don't think it would be a very good political science webinar if we don't have a question about the conflict between the parliament and the judiciary. So yeah, over to you, sir.
Yeah, absolutely. But Gaurav, you laid down question which was very interesting, and then you say, how can this be changed? I would say, why should this be changed? Because democracy, isn't that very healthy where we do have Parliament, which is supreme in terms of lawmaking, no doubt on that account. And judiciary is supposed to test its constitutionality. Judiciary is not supposed to make law. I'm slightly taking, thanks to Arman, he's given me some time. In Putta Swami judgment, which is thick. Actually, I carried the entire judgment to Shahid Bhagat Singh College when they had this discussion on privacy and gave to students. Operative is just 2 pages. And judges very clearly say that they are not rewriting the constitution. Judges say that they're reading right to privacy in Article 19 and 21. They're reading that, they're not rewriting. That's what they say. So many times, constitutional provisions opens up possibilities of new understanding, new interpretation. Judges do so. There are cases where there's been complete, opposition to each other. Again, many of you won't remember, this is probably 2001 judgment or something like this. It's known as Little Man case, where for the first time it was legislated that those who wish to fight elections will have to share their antecedents in terms of their criminality, whether cases have been filed or not, their asset and others, and this will be meant for citizens in general. And by that time, new technology had arrived. It was put on website. So Delhi High Court came with a judgment. Parliament passed a law against that. Supreme Court intervened and said, no, this has to stay. But then Parliament resolved not to question Supreme Court. In many ways, it's important, at least we come to know, at least, ADR, Association for Democratic Rights, goes through affidavit filed by all the candidates. They give you data, how many criminals are fighting, how many accused are fighting, what was the asset last time, how much they have earned this time. It may have an implication for elections, may not have. That's a different matter, but at least right to know came in. But then the third bundle of cases, which is known as judges case, where how judges would be appointed, first judge case, second judge's case, third, and finally NJAC case, National Judicial Commission case, where judiciary said no, executive should not have a role to play. It's not that judges actually appoint judges. That's, remember, one of the speeches from Rajya Sabha member, which was much quoted newspaper. It was very clearly stated that, judges do initiate, but vetting is done by executive. Okay. So, and as per protocol, if next time again the collegium passes, then executive will accept it. But executive has also a way to actually sit over it. So it should be there. It should be there. Debate is about overreach. Would you make policy? Road making is not court's work. It is work of the executive. Okay. Lawmaking is work of the parliament. Supreme Court cannot, and Supreme Court actually is not making law as such. It may test this thing. So let these boundaries remain over there. Let us have a strong judiciary, fine, which and in that sense, journalists who are arrested, forget about journalists, they of course go to even any member of parliament or assembly who's arrested, remember their statement, you remember, they say, I have full trust in law and judiciary will do its own work. So they also trust when it comes to criminal prosecution of them. So I would say, Gaurav, let it be there, fine. There have been times of judicial overreach. Anuj Bhavania has come with brilliant work where he's shown this overreach, and the courts have themselves retraced their steps back. Courts have actually remained silent in times of worst excesses. Okay, internal emergency was one period; they remained silent. Okay, even if you go back to around year or two, different high courts were taking stand when it came to lynching and other cases. Supreme Court wasn't. So if not one another layer of courts come in, they take stand. So that delicate balance is there, and I hope that delicate balance continues, Gaurav. But again, these are very good questions which are coming up. These are good write-up. You can actually write a good paper on this based upon cases. And then soon you people, I don't know whether your batch or others, but with new education policy, you'll have to write research papers and others. And your class seems to be so well equipped. Many congratulations.
Thank you. Thank you so much, sir, for those very, very kind words at the end. And I think Gaurav's question is answered partly in your lecture as well when you spoke of checks and balances. Unfortunately, I have to say that we don't have a lot of time, and we do have some very interesting questions in the chat which I would have loved to take up, and I apologize to Abhay, Raj Rawat, Vaibhav Singh and Alok Ranjan for not being able to take up their questions. But may I now please invite Rupinder ma'am to provide a formal vote of thanks.
Thank you, Professor Ujjwal, for this very, very interesting, fascinating, I would call it as interaction, more than a webinar. It seemed like a very thick interaction in terms of decoding and understanding the Constitution, which we follow. And it sort of underscores that our Constitution is very, very nuanced. It is nuanced, and there are definitely the contestations, paradoxes or dilemmas, but we have sort of steered through them, and the strength of the Constitution is that it allows these kind of dilemmas and paradoxes to be discussed in open platforms. That is what is most fascinating for me. And this appeared more like a brainstorming session for me. And personally, Professor Ujjwal, you were there in my screening committee, and I remember you told me, Rupinder, you need to read the Constitution again. And you promised me to gift one to me, but I definitely will pick up and try to understand, because I don't specialize in the Indian Constitution, but I think every political scholar and every political scientist needs to read and reread the document many times, because the more you read it, I think it is so layered in its richness that we get to understand and we get a new perspective of seeing our society and how, what Arman said, how we balance the liberal and the illiberal aspect of the Constitution. But fascinating discussion, very engrossing discussions. And I request Arman that some of the questions which remain unanswered today needs to be mailed to Professor Ujjwal. And all the homework was done by the students, I was just in the background, and all the questions were articulated and discussed among them, and they came up with a very interesting question, which allows me also to dwell into them personally at my level also. So Professor Ujjwal, thank you on this eve of Republic Day. We had a very fascinating and enriching discussion. Thank you for sparing the time. It's a total privilege to have you. Yeah. Thank you
so much. It was just amazing session, and you could see I didn't have answer to most of the questions which was raised, but thank you. That's the best part. Learning so much from all of you.
No, I think it was the questions were very good. We need to see the mindset of these young students, and they're very bright students. And many times I don't have answer to the questions, and they ask me in the class too. And I think that's what students should do, to continuously challenge us to revisit our own thinking and our own perceptions about things. And that's the best part of teaching and learning. It continues together. I think I now need to invite her, who is the president of La Politique, to give the final vote of thanks to Professor Ujjwal.
Good evening, sir. मैं अपने मुख्य अतिथि प्रोफेसर उज्ज्वल कुमार सिंह सर को धन्यवाद देना चाहता हूँ, जिन्होंने इस इवेंट को अपने प्रेरक विचार से सम्मानित किया. I also express my heartfelt thanks to our professor, principal, ma'am, departments, students, volunteers for making this event a great success with them, sport and vision. Thank you.
I would also like to invite Gaurav sir. He has raised his hand.
Excuse me. I would like to add a few words and say a few words.
Yes, sir. Go ahead.
Yeah, please.
Thank you. Pranam sir. I was a student of yours, in 2012 batch, MA, and I remember your interactive classes, lectures like this, and it always helps students in learning in a better way. You used to walk around the aisle and then at the corners of the classrooms, and then ask students and see if we really have learned or not. So it's really, really fortunate to hear you again. And you look the same as it was. So it's brilliant, sir, to listen to your lectures. And I'm delighted for our students, and, that they might have learned a lot from your lectures. Thank you, sir, for your lecture. Wonderful lectures.
Thank you so much. Yeah, I think we can take leave now. Thank you so much, Arman and Ishka and Upinder, Mehndi, Gaurav, Harsh. That's what these are the faces I can see. So I like this interactive session. So bye for now and all the best.
Thank you. Thank you.
Thank you, sir.
Thank you, sir.